Look, here's another big story. I told you last week I went down and I didn't see the whole case, and I wouldn't have known half of what I saw anyway because it was in the High Court in Wellington. A legal argument between the Waitangi Tribunal and, well, essentially Oranga Tamariki and the minister responsible for OT, Karen Chhour, who wishes to repeal and as part of the coalition government's plan is repealing certain policies or directives in legislation that says Oranga Tamariki must essentially pay regard to the maintaining the familial links of Māori children when it is placing or uplifting people from care, and that you must try and keep Māori kids connected to their whakapapa, to their family unit one way or another. That's going to be got rid of because the new government says it's just all about the welfare of the kid and the other stuff doesn't matter. And the Waitangi Tribunal says that's wrong, and it's holding an inquiry into it. Whether or not that inquiry has any effect is a moot point in itself. But by way of background, the tribunal then required the minister, Karen Chhour, ACT MP, to appear and give evidence about the formulation of this policy, one understood, before the tribunal, and she said, nah. Not going to. They tried to subpoena her and they had an argument in the court about whether or not the tribunal could compel a minister to give evidence. Well, last week, the Crown appeared to win. I'm interested in how it won, but now we have a lawyer called Annette Sykes saying we're going to appeal that decision. So what are the grounds for appeal? I'm not a lawyer. And even lawyers sometimes don't know what they're doing, but one who does, and I think it always gives good perspective on this, and I saw him down at the case, so I know he's been there, is Graeme Edgeler, and Graeme joins us now. Graeme, how are you?
I'm good, thank you.
This is, I'll be honest, as a layperson, what the hell's going on here, Graeme?
Well, I mean, you summarised correctly. The Crown won this one. Mm-hmm. Crown said the minister doesn't want to turn up, and court tell the Waitangi Tribunal that the minister doesn't have to turn up, and that's what the court did. And, the decision, if you sort of read it and you start reading, he's like, the Crown's not doing well here. Crown's not doing well here. A lot of things went against the Crown, and they, not particularly harsh criticism, but there was some criticism. I mean, the reason that we got to this point is the minister decided not to front to the Waitangi Tribunal and defend her policy, which, when they need to, ministers historically have done. One thing I will correct. That you said the Waitangi Tribunal has said that this is the problem, the repeal of Section 7AA. They haven't yet.
Okay, but they've said we're going to inquire into it. There's an issue there they're going to inquire into to work out if it is a problem. Yeah. And one of the sort of couple of reasons why the Crown won in the end was basic question: can the Waitangi Tribunal do its job in this particular case? With the evidence that they have got without the minister turning up. And the judge said, they've got enough that they can do their job. They might need a bit more, but it's not necessary. And one thing the tribunal can do, this isn't a criminal case, it's a civil sort of case, it can take account of the fact that the minister decided not to defend the policy. Was unwilling to say, here's why it's a good idea. And so when the Waitangi Tribunal does reach its decision, which is only recommendatory, it's not going to... it doesn't have binding, it doesn't make binding findings, so it has the power, I understand, of a Royal Commission of Inquiry. Yes. It's established with that power.
Yes, and so, if the minister wasn't willing to defend it and say why this was a good idea to repeal this, the Waitangi Tribunal might just look at that and say, one of the things we take account is, if it was a good idea and the minister had a good enough reason, that meant, here's why, she'd have told us what it was. Yeah. And so the Waitangi Tribunal can take that into account. So I think it's quite likely that they will find it does, and one of the reasons that they will find it does, won't be the only reason or even the main reason, perhaps, although who knows what they'll actually recommend or find. If the minister was unwilling to defend it, maybe that gives you a bit of a steer as to what the result is. And so, sort of the Crown is in
but equally, it is a decision made collectively by Cabinet, and there was much talk during the hearing of a thing called, was it Comity? Comity. Now, what the hell is Comity? I'm sorry, Graeme.
It is the different parts of government. Well, in this particular, I think the word can apply to things that aren't government. But in the context that courts in New Zealand use it, it's we do our thing, you do yours, sort of. So the courts don't overstep their bounds. The Parliament doesn't overstep. The Crown doesn't. They all sort of recognise. You'd had various people get in trouble for criticising sentences or something like that, or why is this person not going to prison, or how did this person get a discharge without conviction? And the idea is one of the reasons courts decide sentences, ministers of the Crown don't, so ministers of the Crown shut up when a sentence has been released or something by a judge. That's for that. And so it's they recognise that each of the other spheres, each of the other branches of government has its role, and they let it do its role, and they don't try and overstep their mark. And so one way is ministers don't criticise court decisions. Another way is, well, the Waitangi Tribunal has this, but
should it be criticising government policy?
Decisions, so it can criticise the government policy, but when a minister decides not to, so in this particular case, not to give evidence to the tribunal, it should, if it really needs it, it can insist. And so one of the results is it is clear that this is a power that the Waitangi Tribunal has to exercise in appropriate cases. Just the facts in this case, the High Court decided it wasn't. But, it recognises that the government has competence to make decisions on what sort of
it's allowed to govern.
That will introduce the Parliament or repeal.
Graeme, is that it governs. But there is going to be an appeal now against this decision that Karen Chhour. Now, who is lodging that appeal, and on what grounds could you possibly appeal this?
It was a close-run thing in the High Court. It was a lot of things did not go the Crown's way. They just sort of won right at the end, where it's the Crown argued that none of the evidence the minister would give would be relevant, and the High Court said, no, I don't believe you. The minister's evidence would be relevant. The Crown argued a lot of things that the court rejected. And said no. The Waitangi Tribunal, the claimants mostly. There was the iwi and hapu and Māori Women's Welfare League, who were the people who made the complaint to the tribunal. They were running most of the argument. The tribunal, spoke for a couple of minutes with some background, but it was the claimants who were doing it. Which is how it usually happens. And it's like, you get to the end, and the one bit effectively the Crown wins on is there enough information for the tribunal to do its job if it doesn't get this from the minister? And because they've already decided this evidence would be relevant and it would be helpful to the tribunal, just, is it essentially, is it stopped from doing its job?
So there's going to be an appeal, but who is launching that? And on what?
One of the claimants.
Okay, so it's not the tribunal itself, but
not the tribunal.
Okay, but the tribunal has to agree to, if you like, be the host of that appeal?
No.
No? Oh, okay. So they've got nothing to do with it.
But they'll turn up. They will be one of the people who is responding to the appeal. So there'll be the appellants. That's the people who are bringing the appeal. Technically, the tribunal will be, responding to it. They won't do very much about it. But yes, it's. I'm trying to remember exactly which iwi or hapu.
It's Annette Sykes,
the law firm represents, but it's essentially her clients.